Breakfast Club. This is Asake Online. My name is Brighton Ncube. I'll be your host for this Breakfast Club meeting this morning. So joining me today is Makomborero Arizubishe, Tarero Sendarai, as well as Darlington Marange, to unpack the issue of detention, pre-trial, and so on. So joining me, I see your mic is your cameras are now on. Good morning to you, Makomborero.
Yeah, good morning, Brighton. How are you?
I'm fine. All right, let's start with our conversation this morning. Let's speak about the issue of trial and pre-trial detention and so on. We know Jobs Kale has been in prison for over a year now. He celebrated his birthday for the over past 2 days there. Let's speak about the issue of trial and pre-trial detention. What's your take on that, Makomborero? Start with you, Makomborero. The issue of trial and detention. Also take on that, Makomborero.
Yeah, thank you for hosting me and asking me this question. The issue of arrest in Zimbabwe from a human perspective, like I'll give my own experiences because I have experienced them many times. But speaking the contemporary political events in Zimbabwe, arrests now, they are a weapon that is now being effectively used against those who are perceived to be opponents of the government. By opponents of the government, I speak to civil society activists, I speak to opposition politicians, I speak to citizens who even speak out against injustice. I'm sure we all know in the just held elections, over 40 civil society, members of the civil society were arrested for doing their work, no crime, nothing. We have Honorable Jobs Kale in jail. We have the Mtwaka's Republic 9. They are languishing. We have Mr. Jacob Ngarufume, is languishing in jail. And we have had more. And also from my perspective, I would delve into my last arrest, maybe to try and use it to show or to explain how the arrests are really being abused against people. My arrest, I wouldn't call it an arrest because I was just ambushed. It was abduction style by men who had balaclavas, they had guns, but I was fortunate to be able to make enough noise. Like they ended up firing gunshots and everything. It was an abduction, but that stimulated enough, attention on social media, and they ended up being forced to surrender me at the police. But at that instance, the police were not supposed to have, arrested me or charged me, considering the way I'd been taken. It was an illegal arrest. Let's say the police have, allowed an injustice to happen. The next layer was the National Prosecuting Authority. Clearly, those people, they are lawyers, they're state lawyers. They could have seen that this is an illegal arrest and it shouldn't have been, it can be prosecuted. But nevertheless, they went through. And the next layer, it will be the courts. Because any competent judge or magistrate could see that this was an illegal arrest. The people who arrested me could not be brought forward because it was an abduction. And them being brought forward means they would be unmasking key state machinery, which is used in perpetrating gross human rights violations against Zimbabwean citizens. So they didn't. But then the court went on to uphold and to prosecute this case, which shows why I mentioned from the police to the National Prosecuting Authority up to the court level is to show how the justice system as a whole, from the police up to the prisons, how it is designed now to persecute political opponents, not for the purposes of meeting the ends of justice, but for the purposes of silencing dissent, of the purposes of threatening the populace. So going further into my trial, my trials were never held, unfortunately, for over a year, for around a year that I stayed in jail. And I would push with my lawyers, would do everything to say, no, look, you're saying you are denying me bail on the basis that you have strong evidence against me that I have broken the law. So let's go for trial. They couldn't kickstart trial. When I apply for bail, they'd say, he trial is about to start, there's serious evidence against him. But I said, no, let's start trial. They couldn't kickstart trial. Why? Because they didn't have evidence. Why? Because the charge that I was given, they were just preferred against me based on nothing, but just because I'm an activist, I'm a human rights activist, I'm a pro-democracy campaigner. So I never had a single trial which was held ever since I was arrested on the 17th of March in 2021. Up to I got out 17th of February 2021 up to I got out in 2022. No trial was concluded, and such bad it is that even when I, of course, left Zimbabwe, my co-accused, they're still going to court over the same case. The trials can't be concluded. This shows how there is, prosecutorial, persecution, where the prosecuting authority abuses its prosecuting power to persecute political opponents, perceived opponents of the government, perceived opponents of the ruling establishment. So this was so sad, and I managed, due to pressure and other things, public pressure, diplomatic pressure, people, civil society, citizens, international, at local, regional, international level, they really put pressure, and it resulted in me being released on bail at some point. And I can tell you that of the cases that had been preferred against me at the point of arrest, they were trying to find anything. They at first even preferred 19, which was absurd, some of the charges. And my lawyers said that, no, this doesn't make sense. And they, slashed them, and I was left with 5. These are the ones that I went to court with. And I can tell you that of those 5 cases, 3 of them I have since, they've since been, I've since been acquitted against those cases. For some of them, I was wrongly convicted at some point. It was just a rushed, judgment, which was irrational. But then I won in the High Court. I was cleared at the Higher Court because they were not dealing on appeal. They will be dealing with points of law and not, so it's a bit difficult, especially considering issues to do with precedents and everything. It would be a bit difficult for them to abuse their judicial capture. So, and it was so sad that after all this period, some of the cases which they said they had impeccable evidence against me, I got acquitted. On others, they can't even kickstart a trial because they don't have evidence. Another one of the cases has been removed from remand, implying that they failed to kickstart the trial. Is the state admitting that they failed to kickstart the trial? So all these are the things that I'm speaking might be about the law, about charges, but I would speak to the undignifying process, that the humiliating process that puts people through from the point of arrest. Like, it was like the way they took me, they abducted me, it was like I was a common criminal, just pushing me. If they really wanted me, if I had committed any crime, it was so easy. They could have just called me or called my lawyers. They have my numbers, they have my addresses. Or they should have just called my lawyers. They've been doing that before to say, no, bring your client here, want to charge them with this and that. But they never did that.
Marco, allow me to cut you short there, Marco, and bring maybe Darlington into this conversation again. On the issue of detention, we know Job Scalia has been in prison for more than 2 years now. So let's bring maybe Tariro into this conversation with Darlington on the issue of detention before trial and so on. Maybe what are the principles governing maybe the issue of denial of bail in Zimbabwe? For example, Scalia has been denied bail many times. Also, Makomboro maybe denied bail as well many times. Maybe bring Darlington. Darlington, what are the principles governing the denial of bail, in particular looking at the Job Scalia issue there?
All right, thank you very much. So the starting point is that when a person is arrested, the state in certain circumstances, before you appear in court, you are arrested at the police station, for example, and then you are then arraigned before the court. You are expected to appear before the court within 48 hours after arrest. And then when you appear before the magistrate court, you are then required in terms of the Constitution, Section 50, not to be released on conditions or unconditional, except in circumstances where there are compelling reasons justifying the continued detention. In those circumstances, then the state can oppose that bail. So if we look at the Criminal Procedure and Evidence Act, there are grounds upon which someone might be denied bail. These are listed in Section 17 of the Criminal Procedure and Evidence Act. So if, according to this provision, these grounds constitute compelling reasons that justify continued detention. So if there's likelihood that the accused person, if he or she is released on bail, likely to endanger the safety of the public or a particular person, the likelihood that the accused person will not stand trial, or in circumstances where if the accused person is likely to attempt to influence or intimidate witness or to conceal evidence or undermine or jeopardize the objective or proper function of the criminal justice system, or in exceptional circumstances where there's likelihood that if the accused person is released, this would disturb the public order and public peace. So those are the circumstances upon which the accused person might be denied bail. So that inquiry, if you look, the inquiry on whether these are grounds that I've alluded to, on whether these grounds are present in each particular case, is an matter of judicial inquiry, and the discretion is on the presiding officer who actually, make those determination on whether if you are released, you are likely to destroy evidence or conceal evidence, you are not likely to appear for trial. All those things is the discretion of the presiding magistrate. So that's why you find out that it is because of that discretion that has now been abused by the judicial officers. So when the judicial officers are given that discretion, sometimes they go against those principles because it's a discretion by anyone. But there are actually principles that are outlined on how the accused person can be denied bail. One of those principles is the presumption of innocence. So this assumes that every person that has been arrested is not yet found guilty. These are just allegations. So when the court is making a determination on bail, it should lean in favor of giving the accused person bail because this person is still innocent. So you would find the state in various cases saying this is a serious offense. Yes, it is a serious offense on paper, but this person is still, innocent. So those are some of the principles. Another principle is the interests of is the court leaning in favor of liberty of the accused person. You find that every person has the right to liberty, and that right can be limited, of course, after the police has a reasonable suspicion that that person will commit and is committed an offense, so they can arrest you. But when the court is making a determination, it should lean in favor of the accused person. So where there's no, after considering evidence from the state which is opposing bail and evidence from the accused person, the court should then lean in favor of granting bail because it is now leaning in favor of a liberty of the accused person. So those are some of the principles that should be applied by the court when they make a determination for bail. But unfortunately, you would find that these principles are applied sparingly in certain cases, but in most cases involving political activists, human rights defenders, you would find that those principles are not applied in favor of the accused person. Yes, back to you.
Well, thanks so much, Jonathan, for highlighting that. Quite interesting what you are saying there. But also, allow me to bring Tariro Sendarai into the conversation as well. Tariro, I know you lead research in terms of the forum as well. I've been working on many things and part of the forum. Allow me to bring you back into the conversation and ask you around the issues of maybe again look at the case of Job Sekala, for example, in your view, and looking at the state of human rights in Zimbabwe, which is when Job Sekala and maybe look at Jacob Ngarivume as well, and in prison. Is there a linkage between the state and of human rights in Zimbabwe and where we find ourselves in Zimbabwe right now, where people are being denied bail, they're being in detention? Is there linkage of the state, the judiciary, and so on? Tariro?
Right. So I think with regards to Job's case, I think it's one of the cases that we managed to spotlight in our 2020 to 2023 trial by pretrial incarceration report is one of the cases that fall within the identified trend where we can see the state weaponizing the judicial system, the prosecutorial system, and making sure that one stays for too long in pretrial detention. And at some point, sometimes their case never goes to trial. I think we heard what Marco said, that some of the charges that were leveled against him, they never went to trial, but he spent almost 1 year behind bars in prison. But also there's also the challenge where some of these cases, you will see that upon spending so much time in prolonged pretrial incarceration, you then end up being acquitted. But we are seeing that this trend is one of the methods that have been deployed by the state to possibly frustrate voices of dissent and opposition political opponents. But also it's something that is of concern because once you get arrested and then you are in detention under the pretrial detention brackets, it becomes a challenge where even if sometimes you are granted bail, your life is inconvenienced in many ways. I'll give examples where the MDCT trio then, who are Cecilia Chimbiri, Honorable Joanna Mamombe, and Netai Marova, when they were arrested in 2021, these three accused persons, they were eventually released on bail. But the conditions of bail were so stringent such that they had to surrender their passports and they were required to report to charge office at least once a week. And it means that even for you to make a living, it becomes a challenge. For you to do other business about your own life, it becomes a challenge, but an unjustifiable one because at the end of the day, they were acquitted, but the inconvenience that was caused is something we cannot ignore. But there's also the psychosocial aspect to it where your name is tarnished, you are dragged in and out of the courts for prolonged periods. This is you being outside of detention, but also your reputation and your good name is then laid bare and attacked. But with regards to Job's case, you'll see that I think he's still in prison right now. He has spent over 400 days in pretrial detention. And again, as per prediction, the state has also leveled additional charges. They leveled additional charges to him. But we know that Job has been someone who's known as being an outspoken critic of the government. So he was also, I think just for information, he was also one of Hopewell's legal representatives in his case. And we see that when he was arrested for the More Blessings Ali case, his crime was for him asking for a dignified burial for More Blessings Ali in the Nyatsime case. So there were skirmishes that happened. Unfortunately, he got arrested and he was leveled with the charge of inciting violence. But of course, he then got other additional charges whilst he was in prison. So when we look at the case here, Job, but also we juxtapose it, I think, with the state of human rights. The Zimbabwe Human Rights NGO Forum managed to compile a 2022 State of Human Rights report, which unpacks the various human rights violations that took place last year. So these also give you a picture of what is happening also in the courts, also how the pretrial detention is being weaponized, but also it's mostly us trying to also zero in, I think, yes, we speak about all the other rights, right to water, right to education, and the rights of the child, but the civil and political rights, that's where we see most of the cases coming in. So some of the emerging issues that were picked in the State of Human Rights report, the 2022 one, are such that we picked cases such as the systematic closure of the civic space. So through the PVO Amendment Bill, we also picked the perennial investigative mode and lack of prosecution by ZRP on cases of human rights violations. So you'll see that there's no accountability in cases where, yes, the state is caught maybe pens down, but also maybe caught as probably the prosecutor, be it in cases of abductions, be it in cases of political violence. They seem to be perennially investigating. These cases never come to an end. Eventually, we never even get to be updated or given feedback as to the final finding of the investigations. Another issue that we picked in our State of Human Rights report is the arbitrary arrests of human rights defenders. So if you look at our table of violations, in 2022, we managed to document 1,996 cases of human rights violations from January to December. And this included unlawful killings, abductions, assault and torture, malicious damage to property, arbitrary arrest and detention. So with arbitrary arrest and detention, we managed to cover 183 cases. Then there's also cases of harassment, intimidation, discrimination, partisan distribution of food, and also selective application of the law. So when I go back to the issues that we have raised, you will see that there's been some consistency in terms of the selective application of the law and the weaponization of the law. So one of them being the trend that we have noted in our other report. So in my view, I think we have a serious challenge in the justice system. We also have a serious challenge in terms of the active demand of human rights, because where citizens are able to actively demand their civil and political rights, there's some form of persecution that comes, there's some form of vindictiveness that comes. Sometimes they are unlawfully arrested, like Makomborero was unlawfully arrested. Sometimes, even if they are arrested, their trials don't kickstart. And in the event that the trials even kickstart, they are then found to not be guilty of any offense, and then they are acquitted. So in essence, even if you may not be in detention, sometimes your life stops, and it's a form of detention itself where you are up and down in the courts, you are being dragged left, right, and center, your good name is being tarnished, but also to say just the psychological trauma that comes with you being in the newspapers, you being spoken about in the social media platforms, and also the vicarious psychosocial trauma that also accrues to your family members, but also to your colleagues and friends. So this is something I wanted to really speak about in detail, to say the forum is launching these two reports. We are going to share the links to the trial by pretrial incarceration report, where we captured cases of 2023 and 2020 and 2023, cases like those of Makomborero, but of course with others. Then also we are also speaking to the state of human rights in the year of 2022. I mean, 2022 has had many challenges. We were coming from COVID, you know, where the civic space was closed completely because of COVID-19. But also where we are expecting that the space opens up from COVID, we realize that there are other challenges that came with the closure of the civic space by discharging of lawfare and laws that constrict the operations of activists, but also of civic society organizations. So this is where I'll end, Brighton. Thank you.
Well, thanks so much. One picking that. Guys, if you're just joining us, this is the Breakfast Club. My name is Brighton Ncube. I'm talking to Tarero Daphne Sendarai, Forum Research Specialist, Darlington Marange, that's human rights advocate, as well as Makomborero Aruzubishe, human rights activist and victim of Pretrial Incarceration. Allow me to drop back now, Tarero, on the issue that you raised there on the report. I was looking at the report there, and I think page 37 there about Makomborero, you have been highlighted there as one of the victims of Pretrial Incarceration. I remember also there was also Takuzo Ngaridzore that we saw as well yesterday being abducted there, that video as well, and Alan Moy as well. Makomborero, let me come back to you. The report speaks on to how you had your bail revoked, and where you in fact incarcerated despite a court order granting you your bail pending appeal, right? This led to social media campaigns where there's Free Marco, hashtag Free Marco, Marco Monday campaigns. Can you give us maybe a personal insight, Marco, into this experience? Also, what's the situation then? Was the situation then alleviated by these campaigns and then led to the release of your release, Marco?
Yeah, what made me stay so long wasn't rather about the revoking of bail or anything. It was more to do with a case which they charged me of after I protested Timbala. Of course, they wanted me inside because we were attacking Impala because Impala was a target because it had been identified at various levels, including the cause of law. It had been identified as a non-state actor in enabling human rights violations in Zimbabwe. From the case of Tawanda Mcheiwa, Takutongazo was attacked again by Impala, and many more people. We know there are cases which have been also recorded, which go as back as 2019 about Impala. So they really didn't want me and others to speak about it. That's why they put me in for so long. So the situation, I would speak more of the experience in prison, given in mind that there's Honorable Job Scala still inside, and people, the Zimbabweans, they I think they need to know more about the day-to-day life inside prison, the humiliations, the undignifying experience which are there, where prisoners are denied even basic hygiene, shortage of water, even appropriate facilities, which, for example, at Harare prison, a cell is supposed to be occupied by 30 people, but you find there will be almost 200 people there, 190, 180, 195 sometimes. There is not even a space to just rest, to just sleep. Use a single toilet, which was supposed to be used by 30 people. It's 190 people using it. There is no water. It means it can't be flushed. So what it means is people are living in a semi-sewer, a cell where you are interacting with human waste in terms of smell and sight. We even go to the issue of food. It's so humiliating. They have all these people inside. They are even putting political activists in there. They are made to stay with the worst of criminals. They are put in G class. It's meant to psychologically make you feel like you are a dangerous criminal, like you've been, you're a reject of society, when it's not like that. And they're also exposed to issues to do with a lack of a proper diet. There is no food, and when it comes, it's stock feed, which practically it's stock feed, because some of the milling we used to prepare the salsa, it's rotten, or even the vegetables that I used is not proper, to such an extent that when I even spent 3 months with convicts when I was wrongly convicted, I saw people with pelagia. It's extreme case of severe malnutrition. So people like Honorable Job Scala, the Republic 9, and Jacob Ngarfume are going through all these things, especially with Jacob Ngarfume, where his sentence is subject, is exposed to enforced labor. And there are also other things like strip searches. They are, strip searches, the way they are carried out, they are done to humiliate, and they are usually done, targeting at activists to dehumanize them. Like you can be strip searched in public, but the Prison Act says you should be stripped in private. But when they do it in public, other prisoners are seeing you naked, also female prison officers and others. So it's done as a way to humiliate people. It's undignifying. It's more of punishment. It's more of, you have already been tried through this pretrial incarceration. It's like you're serving a sentence, yet you still have your rights, yet you still have not been convicted. So these are some of the plights which others like Honorable Job Scala are going through, the likes of Dwaka's Republic 9 and Ms. Jacob Ngarfume. So also with my case, I had the advantage that I knew that they would come for me because they were searching for me through illegal means and everything. So I knew that either way I might end up in hospital injured by them, or in the grave killed by them. They fired gunshots upon my arrest, or in jail. So there was also prior coordination. People in Zimbabwe, at national level, international level. And there are many people whom I, participated in my case, raising my case, such an extent that had they not done it, I wouldn't have gotten out. So it's a critical component which the world out there must know. Because I saw in this Zoom meeting, the Susan Kerr there, she was working, she was the country coordinator working for Zimbabwe at Amnesty International UK. She did a fantastic job in terms of updating periodically the Foreign Office with my case, and also the House of Lords, Lord Johnny Odds in the UK. Then we had also in Zimbabwe people who were protesting on the ground, civil societies in the region, and the media. They did wonderful, and I hope that if the same is done for those who are in jail, like Job Sikala and others, it will be very useful. Thank you.
Well, thanks so much, Makombore, for highlighting that. Maybe in closing, I see we have left to 7 minutes before our Zoom ends. Maybe in closing, I'll give maybe each speaker 1 minute each, maybe to close off. My question to you, all of you, 3 of you guys, this morning is maybe moving forward and in closing, how can we ensure that judicial officers, our courts, exercise their functions independently, impartial, and without fear or favor or prejudice, regardless of one's political affiliation? We have seen different cases in Zimbabwe where this one for this political party, but they're treated differently. What can be done going forward? I'll start with you, Darlington. What can be done going forward? 1 minute for you, Darlington.
All right, thank you, Brighton. So I think in terms of recommendations, we have quite a number, I think, to government. I think that can improve our justice system, but also afford victims of pretrial incarceration, I think, some comfort to say in the future they will not experience that, or anyone that they know will not experience the same. So one of the recommendations I'll give is that the state should not politicize the role of judicial officers. I think this is very self-explanatory, but also the investigative role of the ZRP or the police should also not be politicized by the state. The state should also apply regional best practices pertaining to pretrial detention through domestication and enforcement of regional instruments that safeguard or guarantee the rights of prisoners. The state must also apply international best practices as well to ensure the protection and promotion of the rights of the detained person. But also you will see that we expect that the state should also prioritize capacitation of judicial officers so that they're able to participate in processes where there is fair trial, and that even those who are arrested, they also can actively demand their rights. So I just look at it and I say quite a number of recommendations. I think after this launch, we can share the report on our website. You will find it there, but also with others personally we'll share. But there are quite a number of recommendations where there's a duty and obligation, I think, with regards to the state to improve, to ensure that they do not weaponize the judicial system, but also they also afford the arrested person the rights that they have, despite them being limited of their liberty. Thank you, Brighton. I'll end there.
Well, thank you so much, Acharya, for that. Let's go to Darlington. Darlington, what are your closing remarks to the question I posed to all of you, my panelists this morning?
So thank you very much. I think, I agree with what Tarijo has already alluded to. But I also think that the issue of independence of the judiciary is at stake here. I think there should be a political will from the executive to allow the judiciary to exercise and discharge its mandate without interference. We might come up with very good recommendation in judicial reforms, but if the executive arm of the government, particularly the president, is not interested and does not value the importance of the judiciary, then it becomes a perennial issue of judicial interference. But I think we need also to leverage on the use of technology. Recently, the Judicial Service Commission has already come up with an integrated case management system. I think we need to leverage on that so that cases are allocated automatically using that system, so that we remove the human aspect where, judge, president, judicial officers that preside over magistrate court assigning specific magistrates to deal with particular cases, and then we are witnessing this systematic, systematic denial of bail, conviction based on, in some of the cases, based on non-existent laws. So I think we need to move towards that direction. Thanks.
Thank you so much, Darlington, for those closing remarks. Let's move on to Makombore. Makombore, what are your closing remarks? In 1 minute, Makombore, my time is running out now. What are your closing remarks and recommendations, Mako?
I think In terms of closing remarks, I want to begin by agreeing with Tyler and Darlington. They said very powerful recommendations, and also I feel like this report came at a timely moment, and we need to really spread it. We need to conscientize people about it. We need to also find opportunities to ensure, as directed by this report, to ensure that pre-trial incarceration, trial by pre-trial incarceration and prosecutorial persecution ends in Zimbabwe. Then also with my last addition, I think we must also make use of instruments within the law like strategic litigation and suing. And now the new constitution, which came post 2013, the 2013 constitution, allows now when suing people who have abused you, you no longer need to sue the police forces or war, but specific officers if you are to identify them. I can give, for example, Honorable Takudzo Ngatsoro was abducted yesterday and tortured, but those people were captured on camera. Those people, if they are to be sued, it would work as a deterrence for, number one, them participating in other abductions, then two, to other officers, because they will know that when they are in hot soup, even the state will not give them a lawyer. It has happened. If you check people like Justina Mkoko, they've won cases against, it was even the police forces, and there are many other cases which human rights lawyers in Zimbabwe have secured victories against prison officers, against police officers who have tortured citizens. And I'm sure it will work as a deterrence measure for people within the system, because remember, the prosecutorial persecution, it begins with the arresting police officers, it begins with those who abduct, it begins at that level for the justice system. So if something's done to them to make them account at individual, at personal level, within the confines of the law, I'm sure it will also go a long way in terms of deterring. But overall, there is need to rewrite the social legal order in Zimbabwe, and it needs everyone to come on board and contribute in various ways. Some of the problems, as we see.
Marco, allow me to cut you short there, Marco. My time has run out. I've left with less than a minute to wrap up the show this morning. Guys, thanks so much for your time this morning, Marco. And that's Marco, an activist there, and Tarero Sendarai, lead researcher there from the forum, as well as Darlington Marange, the advocate for human rights. Thanks so much for your time this morning. This show is kindly brought to you by the Zimbabwe Human Rights NGO Forum. Their report is coming out in a few days. Trial by pretrial incarceration, detention without trial, and delayed trials in Zimbabwe from the period of 2020 up to 2023. Thanks so much for your time this morning. My name is Brighton Ncube. This is Asake Online, the Breakfast Club. Enjoy your day and do enjoy the rest of the show. Bye.